Hi everyone. Indiana has recently had some changes to their end-of-life documents. There's been a form that's been added that pre-hospital providers will begin seeing probably fairly soon. So I thought it would be a good time to go over the various end-of-life documents that Indiana has in the statute and review some old information and to talk to you about the new information. Okay, so the next couple of slides will be objectives for the program. By the time you finish this, you should be able to explain to patients and other healthcare providers the importance of advance directives, and you should be able to explain what an advance directive is and how it's created. And for our last objective, you should be able to differentiate between the different types of end-of-life documents from the state of Indiana. Those will include the Living Will Declaration, the Life Prolonging Procedures Declaration, the Out-of-Hospital Do Not Resuscitate Declaration and Order, and the new Physician Orders for Scope of Treatment, or POST as it's being called, and also the Psychiatric Advance Directives. Each time you visit your physician, you mention regarding your personal health care. You tell your physician about your medical problems. Your physician makes a diagnosis and informs you about available medical treatment. You then decide what treatment to accept. That process works so you are unable to decide what treatments to accept or become unable to communicate your decisions. Diseases common to aging, such as dementia or Alzheimer's disease, may take away your ability to decide and communicate your healthcare wishes. Even young people who have strokes or accidents that may keep them from making their own healthcare decisions. Advance directives are a way to manage your future healthcare when you cannot speak for yourself. Advance directive is a term that refers to spoken and written instructions about future medical care and treatment. By stating their healthcare choices in an advance directive, patients help their family and physician understand their wishes about their medical care. Indiana law pays special attention to advance directives. Advance directives are normally one or more documents that list a patient's healthcare instructions. An advance directive may name to make healthcare choices for them when they cannot make the choices for themselves. If they want, they may use an advance directive to prevent certain people from making healthcare decisions on their behalf. Advance directives will not take away a patient's right to decide their current healthcare. As long as they are able to decide and express their own decisions, the advance directives will not be used. This is true even under the most serious medical conditions. Advance directives will only be used when you are unable to communicate or when their physician decides that they no longer have the mental competence to make their own choices. Advance directives are not required. A hospital cannot require anyone to make an advance directive if they do not want one. No one may discriminate against a patient if they do not sign one. Physicians and hospitals often encourage patients to complete advance directive documents. The purpose of the advance directive is for the physician to gain information about the healthcare choices so that the patient's wishes can be followed. While completing an advance directive provides guidance to the physician in the event that the patient is unable to communicate, no one is required to have an advance directive. If a patient does not have an advance directive and is to choose medical care or treatment, Indiana law decides who can do this for them. Indiana Code 16-36 allows any member of the immediate family, meaning your spouse, parent, adult child, brother or sister, or a person appointed by a court to make the choice for them. If a patient cannot communicate and does not have an advance directive, the physician will try to contact a member of the immediate family. Healthcare choices will be made by the family member that the physician is able to contact. A healthcare representative is a person the patient chooses to receive healthcare information and make healthcare decisions for them when they cannot. To choose a healthcare representative, a patient must fill out an appointment of healthcare representative document that names the person they choose to act for them. The healthcare representative may agree to or refuse Medicare treatments when the patient is unable to do so. The representative will make these choices based on the Advance Directive. If you want, in certain cases and in consultation with the physician, a health representative may decide if food, water, or respiration should be given artificially as part of their medical treatment. Choosing a healthcare representative is part of the Indiana Healthcare Consent Act, found at Indiana Code 16-36-1. The Advance Directive naming a healthcare representative must be in writing, signed by the patient, and witnessed by another adult. Because these are serious decisions, a healthcare representative must make them in the best interest of the patient. Indiana courts have made it clear that decisions made for you by your healthcare representative should be. A living will is a written document that puts into words wishes in the event that they become terminally ill and unable to communicate. A will is an advance directive that lists the specific care or treatment a patient wants or does not want during a terminal illness. A living will often includes directions for CPR, artificial nutrition, maintenance on a ventilator, and blood transfusions. The Indiana Living Will is found at Indiana Code 16-36-4. This law allows the patient to write one of two kinds of advance directives: a living will declaration or a life-prolonging procedures declaration. Both of these documents can be canceled orally, in writing, or by destroying the declaration itself. The cancellation takes effect only when the patient tells their physician. For either of these documents to be used, there must be two adult witnesses, and the document must be in writing and signed by the patient or someone that has permission to sign their name in their presence. The Living Will Declaration is a document that is used to tell the physician and family that life-prolonging treatment should be used so that the patient is allowed to die naturally. The living will not have to prohibit all prolonging treatments. A living will lists a patient's specific choices. For example, a living will may say that a patient does not want to be placed on a ventilator, but that they want a feeding tube for nutrition. It may even specify that someone else should make the decision for them. The Life-Prolonging Procedure Declaration is a document that is the opposite of a living will. A patient can use this document if they want all life-prolonging medical treatments used to extend their life. For situations outside of a hospital, the out-of-hospital not resuscitate declaration and order is used to state the patient's wishes. The out-of-hospital do not resuscitate declaration and order is found at Indiana Code 16-30-5. This law allows a qualified person to say that they do not want CPR given in the event of a cardiopulmonary arrest outside of a hospital. This declaration may override other advance directives. The declaration may be canceled by the patient at any time by a signed and dated writing, by destroying or canceling the document, or communicating to healthcare providers at the scene their desire to cancel this order. The Physician Orders for Scope Treatment, the newest end-of-life document in Indiana. It was passed in the 2013 General Assembly and became effective July 1, 2013. It is located at Indiana Code 16-36-6. A Physician Orders for Scope of Treatment, also referred to as a post-PST form, is a direct physician for a person with at least one of the following conditions. 1. An advanced chronic progressive illness. 2. An advanced chronic progressive frailty. 3. A condition caused by injury, disease, or illness from which, to a reasonable degree of medical certainty, there is no recovery and death will occur from the condition within a short period of time without the provision of life-prolonging procedures. And 4. A medical condition that if a person were to suffer cardiac or pulmonary failure, resuscitation would be unsuccessful, or within a short period of time, the person would experience repeated cardiac or pulmonary failure resulting in death. In consultation with the patient and/or their legal representative, a physician will write orders that reflect the wishes of the patient with regards to CPR, medical interventions, defined as comfort measures, limited additional interventions, or full treatment. Also antibiotics and artificially administered nutrition. The patient also has the option on the post form to designate a healthcare representative. The Indiana Post form is available on the Indiana State Department of Health website at www.in.gov/isdh/25880.htm. The post form must be signed by the patient or their legal representative and the physician to be valid. The original form is the personal property of the patient, and it is suggested that they keep it. Paper, fax, or electronic copies of a valid post form are as valid as the original. The physician is required to keep a copy of the post form in the medical record, or if the post form is executed in a healthcare facility, the facility must maintain a copy of the form in the medical record. The post form may be used in a healthcare setting. Executed post forms may be reviewed at any time by any of the following. 1. A signed and dated writing by a legal representative. 2. Physical cancellation or destruction of the post form by the patient or their legal representative. 3. Another individual at direction of the patient or their legal representative. Or 4. An oral expression by the patient or their legal representative of intent to revoke the post form. A revocation is effective upon communication of revocation to the healthcare provider. Now we'll take a closer look at the various sections of the post. Section A gives the patient choices about whether or not they want CPR performed on them. Section B gives the patient choices about medical interventions. There are choices on comfort measures, limited additional interventions, and full intervention. Section C gives the patient choices about the use of antibiotics. Section D allows the patient to decide about artificially administered nutrition. Section E documents who the decisions have been discussed with and provides a space for a signature of the patient and their legal representative. Section F provides space for a signature from the physician. The second page of the post provides information and instruction on completing the form and gives the patient an opportunity to designate a healthcare representative. Another type of advance directive is the Psychiatric Advance Directive. Any person may make a psychiatric advance directive if he or she has legal capacity. This written document expresses their preference and consent to treat measures for a specific diagnosis. The directive sets forth the treatment of a mental illness during periods of incapacity. This directive requires items in order for the directive to be valid. Indiana Code 16-36-1.7 provides the requirements for this type of advance directive. A power of attorney, also referred to as a durable power of attorney, is another kind of advance directive. This document is to grant another person say-so over the patient's affairs. The power of attorney document may cover financial matters, give health care authority, or both. By giving this power to another person, the patient gives this person their power of attorney. The legal term for the person that they choose is called an attorney-in-fact. The attorney-in-fact does not have to be an attorney at law. The attorney-in-fact can be any adult that the patient trusts. The attorney-in-fact is given the power to act for the patient only in the ways that is listed in the document. The document must list the following things. Number 1, name the person they want as the attorney-in-fact. Number 2, list the situations which give the attorney-in-fact the power to act. Number 3, list the powers the patient wants to give. And number 4, List the powers the patient does not want to give. A power of attorney document may be used to designate a healthcare representative. Healthcare powers are granted in the power of attorney document by naming the attorney-in-fact as healthcare representative under the Healthcare Consent Act, or by referring to the Living Will Act. When a power of attorney document is used to name a healthcare representative, this person is referred to as the patient care power of attorney. The healthcare power of attorney generally serves the same role as a healthcare representative in a healthcare representative advance directive. Including healthcare powers could allow the attorney-in-fact to make choices about your healthcare, sign healthcare contracts for the patient, admit or release the patient from hospitals or other health facilities, look at or get copies of the patient's medical records, and do a number of other things in their name. The Indiana Powers of Attorney Act is found at Indiana Code 30-5. The power of attorney document must be in writing and signed in the presence of a notary public. The power of attorney can be canceled at any time, but only by signing a written cancellation and having the cancellation delivered to the attorney-in-fact. It is important for patients to discuss their advance directives with their family and healthcare providers. Healthcare cannot be followed unless someone knows their wishes. A patient may change or cancel the advance directives at any time as long as the patient is of sound mind. If a patient changes their mind, they need to tell their family, their healthcare representative, their power of attorney, and their healthcare providers. They might have canceled their decision in writing for it to become effective. Patients should always be sure to talk to their physician and tell him or her their exact wishes. Now the next few slides will be a short quiz, and you'll need to pass the quiz at the very end to continue on with the presentation. Congratulations! You've reached the end. The Indiana State Department of Health has an excellent resource available if you're looking for additional information. The Advance Directives resource website is listed on the screen. All of the forms, information booklets, and Indiana code references are available on this website. If you have any questions on this subject, feel free to contact me anytime, either by telephone or by email. Have a great day.